The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Please be seated. We're glad you could be here with us today. Welcome. We're hearing 3 cases today, and we can start with our first, number 24-1261, John Koontz versus SN Servicing Corporation.
May it please the court, my name is Jay Stone King. I'm with the law firm of Bailey and Glasser, and today I'm representing the plaintiff, John Koontz. This case presents a vitally important issue for consumers. Where there's a clear violation of the FDCPA, is the lender effectively given an immunity for that violation simply because the debtor obtained a bankruptcy discharge? We believe the answer to that question is an emphatic no, and that's supported by 3 cases. The first case is Johnson versus Home State Bank, where the Supreme Court held that even where a debtor's personal liability has been discharged, the debtor still has an enforceable obligation under the note and the mortgage. Next is Obdusky versus McCarthy and Holthus, where the Supreme Court held that foreclosure is, in fact, a form of debt collection that's subject to the FDCPA. And the third case is Guthrie versus PHH Mortgage, where this court held that a claim alleging debt collection violations isn't preempted by the bankruptcy code and can be brought even after a debtor has received a discharge. And these 3 cases together completely undercut the trial court's finding. Specifically, the trial court held that the lender, in this case, through its servicer, no longer had any relationship with Mr. Koontz, and that Mr. Koontz's mortgage debt was no longer an enforceable obligation. And because the trial court got it wrong, we ask for a reversal so that Mr. Koontz's debt collection cases can proceed. Very briefly, Mr. Koontz went through a bankruptcy in 2017 and obtained a discharge from the bankruptcy court. Coming out of the bankruptcy, Mr. Koontz, like many debtors, chose what's come to be known as the ride-through option. He brought the loan current and began making payments every month under the terms of the note. And he faithfully made those payments over the course of the next 6 years. Eventually, SN Servicing became the servicer for this mortgage loan, and right away it began charging.
Do we have to decide right now whether he in fact faithfully made the payments? I think your friends on the other side disagree with that.
I'm sure they do. No, that is not essential to deciding the issue on this matter because it's in the form of a motion to dismiss.
Well, can you explain how this bankruptcy ride-through works?
Certainly. I know that one of the options for a debtor is to reaffirm the loan. And if the loan is reaffirmed, then the debtor comes out of the bankruptcy with his personal liability intact. And a ride-through differs from that because rather than reaffirming, the debtor comes through the bankruptcy with only a non-recourse obligation. And that's essentially where the...
Which sort of creates a have your cake and eat it too kind of situation for the debtor because you're not personally liable, but you still get to keep the house. What does the creditor get when the debtor does? I mean, I guess they don't have to foreclose. It just seems to be this weird sort of like you can get both the bankruptcy discharge and get to keep your stuff, which admittedly, it's been a long time since I've taken bankruptcy, but my normal understanding is the whole point of bankruptcy is I don't get to keep my stuff, and in exchange, my debts go away.
Yeah, I'm not a bankruptcy lawyer either, but the ride-through was originally something that was developed through case law. This court, in fact, adopted the ride-through for bankruptcy cases arising in our bankruptcy courts, and then Congress in 2005, I believe, revamped the bankruptcy code and basically codified ride-through for home mortgages. It was eliminated for personal property, but it was codified for situations like this where there's a home and a home mortgage.
Can you address your colleague's argument about the Lovegrove case?
Yes, I've got a couple of things to say about Lovegrove. Lovegrove is really only relevant to the assignment of error relating to whether this servicer, SN, was engaging in debt collection activity. The first issue is whether the discharge eliminates any claim that Mr. Koontz has, and we certainly argue that it does not. Lovegrove dealt with the debt collection aspect of the case, and it's distinguishable for a couple of reasons. Number one, the issue in Lovegrove was whether the lender was attempting to collect a debt that had already been discharged. Was the creditor trying to collect personally against the debtor a liability that had already been extinguished through the bankruptcy process? But this case is different. This case is an illegal fee case, and it has all the hallmarks of debt collection. SN charged a late fee. SN sent correspondence to Mr. Koontz notifying him of the late fee, and there was a threat, a specific threat that was made concerning foreclosure.
Right, but there was also a disclaimer.
There was a disclaimer, but we don't believe that the disclaimer is applicable in cases involving actual obligation. The disclaimer ordinarily comes up in cases alleging an alleged obligation, and Lovegrove was one of those. As I mentioned, the case in Lovegrove was a debtor who came out of bankruptcy. The lender allegedly was attempting to collect the debt personally, even though the debt had already been discharged. That's an alleged obligation case. And so in that kind of a scenario, it's certainly relevant to be looking at the disclaimer, because you look at all of the circumstances to determine whether there's debt collection happening. And so the disclaimer is a part of that mix.
Can I ask you a question about the debt collection issue? And we have these two letters in the record.
Yes.
And what do you want us to say about those, that they are on their face and as a matter of law, debt collection efforts, or that your client adequately alleged that they, I just don't, I'm not sure what you want us to hold with respect to those letters.
Well, I think that at this stage, the motion to dismiss stage, it's only necessary for you to say that we adequately pled that those letters were in fact debt collection.
I mean, what's discovery going to add to the mix here? We have the letters in the record.
We do. And I don't know that it would add much. I think it usually comes down to a judicial call without factual inquiry. But
Can I ask you actually a question that is somewhat related to that one? And I'm sort of jumping ahead and assuming, it goes to the nature of the relief that you are seeking. And I'm really just making a bunch of assumptions for the sake of argument. But if I just assume theoretically, I agree with you that the district court was incorrect in its reasoning. You want us to reverse and remand, obviously. And would the idea be like we're reversing, we're remanding, and this case goes to discovery? Or are there other motion to dismiss arguments floating out there that the district court hasn't yet addressed?
so far as I know on this record, there are no other motion
Okay.
to dismiss issues.
So you want us to write an opinion that says reversed, you got this wrong, this case goes to discovery?
Yes.
Okay.
And again, going back to Lovegrove, Judge Berner, we believe that Lovegrove simply doesn't apply to this kind of case, an illegal fee case, because you're looking at those two letters. One of them specifically assessed a fee. It's the only thing in the letter. It's a statement that there is a fee that's being charged to your account in the amount of, I believe it was $24. And that fee is due and owing, and then there is a specific threat of foreclosure. And in fact, the irony is that this threat of foreclosure was actually in the disclaimer. So the disclaimer is at the top of the letter. It's in all caps, it's italicized, so clearly it's meant to draw the eyes of the reader. And what the disclaimer says is that this is a step in the enforcement of our mortgage rights, our right to proceed with our lien, and the rights that we have to enforce our lien.
I guess, Counsel, the way you're presenting the argument, these are sort of two separate questions. One is there an obligation?
Yes.
And then if there is this debt collection activity? But it strikes me that they're somewhat related because you're relying on language from the Supreme Court that basically says, look, a foreclosure is a means of enforcing a debt. And if that's
Yes.
right, and a letter says we're going to foreclose, how is that not threatening collection? It seems to me that your arguments are actually quite related.
They are interconnected. I believe that's correct, Your Honor. And again, the irony is you have within these letters the threat to foreclose, which is being made in the disclaimer. So it's an attempt to disclaim something that the disclaimer itself is in fact doing. It is threatening to enforce a lien. And you're correct, Judge Harris, the Obdusky case clearly states that foreclosure, any kind of lien enforcement, is debt collection activity.
Can I take you to the 1692E part? So this is the part where alleging that they did something that violates the statute. And as I read the district court said, on that part of it, you did not plead enough under E, but you did plead enough under F. First, is that your understanding as well? That's what the district court said?
I believe that's correct.
Okay, so then in your brief, you say basically in a sentence, the district court was wrong about the E conclusion. This is on page 10 of your brief. I mean, but the district court, what I read the district court as saying is, you haven't adequately alleged a violation of E because you just assert a violation of E without saying how or what violated E. And then I have a brief from you that says, but we did. So what is the best thing you've alleged that would support a violation of E?
I'm sorry, Judge Hayden, what was the page number?
Sorry, this is page 10 of your brief.
Okay.
Third, the district court erroneously concluded that Mr. Koontz failed to sufficiently plead false or misleading representations. Sorry, the section of the brief is 33 to 35. That's the part of the brief that you make the argument. What the district court said, you haven't identified what subsection of E you claim they violated. What subsection of E do you claim they violated?
I don't know that we have to specify a
Let's
subsection.
assume for the
We just
sake of
have
argument that, okay, what conduct, well, I don't know if you have to specify in your complaint, but for me to conclude that you've adequately stated a claim under E, I have to know what part of E you're claiming they violated. So what part of E are you claiming they violated?
Well, I think our allegation would be that, that there was conduct by the lender that misrepresented the status of this debt.
And I don't have E in front of me. What subsection of E does that
I
violate?
apologize, I don't have that part of the statute in front of me either. But clearly, you have a misrepresentation of the debt and the amount that's owed under the debt. And that's a classic way of pleading and presenting these kinds of debt collection claims.
It just seems weird to me if the district court says you haven't stated a claim because you haven't identified the subsection and you still can't identify the subsection.
I apologize for that, Your Honor. And if it would be helpful, Judge, I would be happy to do that following today's argument. I can see that I'm coming close to the end of the argument, so I do want to tie up a couple of things if I can. number one, we believe that the trial court here certainly should have followed Johnson and Obdusky. And there was actually a case that was in the, it came out of West Virginia, the Northern District of West Virginia, which came out a few days before this order was entered. And the case was Parsley, and it really nicely sums it up. Once a consumer, always a consumer. And so there's no question here that, that our client, Mr. Koontz, was a consumer. He signed the note, he signed the mortgage, he entered into this obligation. And the fact that there was a subsequent discharge does nothing to change his status. And we would also urge the court to hold, as we've argued before, that when a lender tries to collect an illegal fee and threatens foreclosure, that's debt collection, and no disclaimer can fix it.
Counsel, thanks very much. I think you have some time for
Appreciate your
rebuttal.
time. Thank you very much.
Good morning, Your Honors, and may it please the Court. My name is Alex Zerba. I'm coming from Charleston, West Virginia, where I practice at Frost Brown Todd. With me here today is my colleague, Blake Humphrey. Together, we represent SN Servicing Corp. Appellant, as I think it's fairly evident in this case, is advancing an untenable theory of liability that flies in the face of a mountain of case law, the pure statutory text of the two consumer acts that we're dealing with, and it ultimately poses real danger in upsetting the application of the bankruptcy code as we know it, namely the mechanisms of reaffirmation and in turn discharge and how those work together and how obligations are pursued, say, in rem once a personal obligation is discharged through the course of bankruptcy. So I think the primary issues and really the primary questions for this court are pretty clear. One, what is the effect of not reaffirming the debt proceeding through discharge, and how does that relate to the very core definitions of the FDCPA and the CCPA, how consumer is defined under those acts and how debt is defined under the FDCPA. And I think we touched on this a little bit in the opening segment. The second primary issue is when we're talking about the type of communication that's at issue here, 2 letters, there's no dispute that there are additional communications. These are the allegations of the communications that are at issue in the complaint. Are those squarely debt collection activities? I believe the Lovegrove case that was discussed at length here makes clear that those are not, that those disclaimers are effective and they're used based on the expectations that are the very product of cases like Lovegrove and that nature. But I want to turn my attention real quickly just to build a foundation here, looking at the actual definition that I'd referenced a moment ago, what a consumer is under these acts and what a debt is. And under the FDCPA and the CCPA share a substantively identical definition of consumer, and that's a natural person obligated or allegedly obligated to pay a debt. And in turn, a debt is any obligation or alleged obligation of a consumer. So there's this obvious tie of a personal obligation for a debt or to qualify as a consumer under these acts. And again,
So can I ask, so I read the briefs in this case, or the district court opinion, I was very sympathetic to your argument about obligation. I genuinely, I'm not messing with you.
Yeah.
But then I read Johnson, and then on page 84 of Johnson, I read the following sentence, and that's about what happens in situations like where a personal liability is discharged. And then there's this sentence that says, either way, there can be no doubt that the surviving mortgage interest corresponds to a, quote, enforceable obligation of the debtor. Now, I don't necessarily know where the Supreme Court got that idea, but why isn't that case just it? Like, it says in a situation where your personal liability is extinguished, but the mortgage exists, the mortgage is an enforceable obligation of the debtor. Why doesn't that just end this issue?
I don't know exactly the context around the Johnson case and where that line comes in.
But the Supreme Court says that that a mortgage that's been the personal liability has been discharged in bankruptcy remains an enforceable obligation of the debtor. And if that's true, I don't understand how this isn't an enforceable obligation.
Yeah, I think that seems to be out of sequence with the litany of
But
decisions.
yet it's
that-
the Supreme Court of the United States.
I understand the hierarchy there. I appreciate that, certainly. I think we look to the Obdusky case also from the United States Supreme Court, and it talks particularly about, what debt collection activity is in relation to.
But this isn't about what debt collection activity is. This is about what an obligation is. And whether there remains specifically, as I understand the question is, a situation where there was a mortgage and a promissory note and the debtor's personal obligation was discharged in bankruptcy, but the mortgage has not been eliminated, is there still an obligation on the part of that person? And I think there's really plausible arguments on both sides to how do you think about it, except the Supreme Court seems to have pretty clearly, to me, unless you can persuade me otherwise, have said, yes, that's still an enforceable obligation.
Against the individual, I wish I were more familiar with that line in Johnson, but I don't think that can square with the application of the bankruptcy code.
Well, let's look at the whole paragraph. The whole paragraph says, we have no trouble concluding that a mortgage interest that survives the discharge of a debtor's this is all on page 84 of Johnson. The discharge of a debtor's personal liability is a claim within the meaning of section 1015, even after the debtor's personal obligations have been extinguished. The mortgage holder still retains a right to repayment in the form of the proceeds from the sale of the debtor's property. Alternatively, it says something else, and then it says, either way, there can be no doubt that surviving mortgage interest corresponds to an enforceable obligation, and these are the critical words, of the debtor, an enforceable obligation of the debtor. That's him.
Yeah, so the Johnson case is obviously dealing with a bankruptcy claim of the creditor in relation to the existing mortgage interest. So I think that's one distinction to draw there. So maybe the focus in Johnson wasn't what the realities are and what the obligations are post-discharge. And I think that's the distinction. That's clearly what we're dealing with here. I mean, there have been a number of cases that the Lovegrove case obviously is predominant. It's an unpublished opinion, but clearly
Well, I agree. There's a separate question about whether what your client did was an effort to collect a debt. That to me is a different question.
Yes.
But there's a threshold question about whether there still is a debt, whether there still is an obligation.
And I think the answer there is squarely no, despite that language in Johnson.
But it's not just Johnson, right? Obdusky also says that foreclosure is what you do to enforce or collect a debt. And so, I mean, I do feel like the Supreme Court is, I'm no expert in this, but I can read Supreme Court opinions, and they seem to be explaining twice how this works.
I think the division there, and I think this, and I'll pull some quotes from Obdusky here in a moment that I think brings this into a pretty clear picture. But there's this distinction between enforcing a debt in personam, right, when there's a personal obligation, and enforcing that via in rem mechanisms, which means pursuing your security interests through foreclosure. So there's a means via in rem foreclosure actions.
But it's not like the statute defines this as a debt or an obligation that is enforceable in personam. Why would it exclude enforcement in rem? Why would the statutory definitions exclude that?
I think the statutory definitions quite clearly contemplate, as I started with, that a consumer is, or that a consumer necessarily means that there's a personal obligation, right? So when that.
Why does it says a person with an obligation, right?
Yes.
So why can't it be a person against whom an obligation can be enforced in rem? I'm not getting this.
I think that would be adding language to the statute, and a number of courts have looked at that, very, very distinction, of course, between the in personam, issue and the in rem issue. So I think that's squarely been decided, and that's the real effect of the bankruptcy code. That Judge Hayden's mentioned. It seems like a scenario where Mr. Koontz wants to have his cake and eat it too. There are really real ramifications, good and bad. Right?
Yeah, but that's an argument against allowing ride-alongs, but that does not appear to be teed up before us.
So you began by saying there was a mountain of cases to support your argument, but you haven't cited any of them. Can you tell us what you're relying on?
Yes, so we've referenced the Lovegrove case at length. There are also litany cases from the district courts of West Virginia.
And the Lovegrove case is unpublished and non-precedential, and your colleague distinguished it on its facts.
Yeah, and I noted just a moment ago, it's apparent to me that is an unpublished opinion, but it can serve for persuasive effects. But
And are there cases, just going back to my question, are there cases out there that say it's not an obligation within the meaning of the FDCPA if it can only be enforced in rem and not in personam? Which are those cases?
Yeah, so Judge Copenhaver, I think, is the first to acknowledge that, and at least in the cases that I'm aware of being cited in the brief. And
Okay.
that comes from the Ballard case from the Southern District. I think
Okay.
that's cited time and time again.
So these are West Virginia cases, West Virginia District Court cases citing other West Virginia District Court cases.
I think that, in fact, Judge Copenhaver's original citation in the Ballard case is to a Second Circuit case, I believe, for this proposition.
How about
that-
Fourth Circuit cases or Supreme Court cases?
Well, I think the Lovegrove, case ultimately, hints on that.
How about published Fourth Circuit cases or Supreme Court cases?
On that point, I don't think so. I'm not aware of that. But the general gist there of that argument is that, and I think you hinted to this earlier, Judge Hayden's, that there's a real distinction between an obligation, as that means under the law, versus a motivation or the voluntary desire to continue to make payments on the loan.
So can I ask you
post-bankruptcy.
about these letters? So can I move to the second question of, is this an effort to collect on a debt? So I'm looking at the two letters. And so they both start by saying, well, the first one anyway, the one dated 2/2/23. It literally says, we are attempting to collect a debt. That's literally what sentence one says. Sentence one says, we're trying to collect a debt.
Yes.
That sounds like trying to collect a debt. So then we move on to the next sentence where it says, if you received a discharge in bankruptcy, which this individual did, and the debt was not reaffirmed, which is true, this correspondence is not and should not be attempt to collect a debt. So, okay, we're going decently for you there. But then it adds these words, as for your personal liability. But this is the point that Judge Harris was making, that these link, so I guess I would interpret that, it's not as for your personal liability, but it is for your in rem liability. And the Supreme Court seems to have told me that an attempt to collect in rem is an attempt to collect a debt. So in some ways, this actually says, this is an attempt to collect a debt as to any in rem liability. That's in fact what this is. And if attempting to collect a debt as to in rem is covered, then it seems like this letter not only doesn't disclaim that, it literally says we're trying to do that.
Yeah, first of all, just one quick note on that disclaimer. It's nearly identical to that which was apparent in the Lovegrove case. And
Lovegrove said something about we're going to foreclose on your house?
no, it started with
Okay.
the phrase that this is an attempt to
Because that
collect a
seems
debt.
like a very significant difference between the two letters. I mean, we were able to say in Lovegrove, oh, there's nothing threatening in this letter. But this one says, unless you pay us, we're foreclosing on your house. That seems different.
I think that's informational. I mean, it's in the sense that this individual knows that they've gone through bankruptcy, right? That their personal obligation has been discharged. They chose not to reaffirm. And the bankruptcy code explicitly permits post-personal discharge letters and communications for informational purposes to advise about the status of the in rem lien on the property. So I don't think that that's threatening or harmful as an individual who may be post-bankruptcy and not current on his payments and otherwise subject to a foreclosure to know where that stands. And that's it. But Judge Harris, I meant to get back to this Obdusky case, and I wanted to drill down on this distinction that's made by, or attempted to be made by appellant here versus what is the actual holding in that case. So this is a quote from Mr. Koontz's brief. The U.S. Supreme Court has recently acknowledged that a non-recourse debt, one that can't be advanced against an individual in their personal capacity, that can be enforced only through foreclosure is still a debt under the FDCPA. That comes from the opening brief at page 26. And this is the holding which appears in the syllabus page of Obdusky from the Supreme Court. And I quote, "A business engaged in no more than non-judicial foreclosure proceedings is not a debt collector." I mean, this letter is not even to the stage where SNSC would have engaged an attorney to foreclose on the property. It's rather at a pre-foreclosure stage, advising of the status of the in rem outstanding liability on the.
I just want to continue reading from the letter where Judge Heitens left off. The next sentence says, "but is instead a step in the enforcement of a mortgage lien against your property." So how is it not a step?
It's certainly a step. It's a piece of information post the individual, the personal guarantee or the personal obligation discharge, and acknowledging that, okay, you, Mr. Koontz, have shed your personal liability on this loan. We still maintain, pursuant to the application of the bankruptcy code in our contractual agreement under the note, the right to ultimately exercise our rights to be made good, or as good as possible, right? And I'll get back to that in a moment, via pursuing our rights on our security interests through foreclosure. So this is, we're not even to the foreclosure step here. So I think the Obdusky case and the holding, the direct holding from that case is magnified in its application to the letters that are at issue here. And that's a point I wanted to make. You can't have your cake and eat it too. Judge Hayden's, it might have been premature in bringing that subject up a moment ago, but that speaks to the sequence of what's going on here. At any time, Mr. Koontz can walk away from this house, and his trade-off in bankruptcy was perhaps that he wouldn't qualify as a consumer under these acts, but that he doesn't have any more personal obligation on these loans. If you take it to the end, Judge Berner, I think through the foreclosure process, and ultimately say the lien value here is $75,000, and the house is sold at a foreclosure sale for $50,000, there's a deficiency judgment there of $25,000 that cannot ever be collected from Mr. Koontz. And that's the power and the benefit that he derived from the bankruptcy.
Can you walk me through, if he had, counterfactually, if he had assumed the loan, what would the differences have been? I guess he clearly would be if he had assumed the loan, you would concede he's a consumer then, right?
Absolutely.
Okay. So what else would happen had he, I'm just trying to understand the difference between these two things. What are the other things about the world that would be different had he done that? Well, I guess he'd be personally liable in the deficiency judgment example you just gave.
So if he would have reaffirmed the debt, Judge Hayden's, and then proceeded through the bankruptcy, there's a discharge of what other debts may have been subject to that bankruptcy, and he would have received a piece of communication that had some incorrect amount on that. He would have qualified as a consumer.
Okay.
And under the facts that were alleged, I believe that would have satisfied the 12B6 standard.
And then further, again, if he defaulted, you had that example where the house is sold for $50 and he owes $75. In that situation, he would be still on the hook for the $25.
Sorry, I should have seen that you were leading me to that point, but yes, absolutely.
No, but I'm trying to think what else would have been different. I'm just trying to think of any. This is genuinely an informational question. I'm trying to understand.
Yeah.
What else would have been different in the world had he done that?
I think you hit the nail on the head there. That with regard to that deficiency judgment in the scenario that I just gave, 75 outstanding on the lien versus a $50,000 foreclosure sale, SNSC, who operates on behalf of the actual owner of the loan, would have been able to pursue that deficiency judgment against Mr. Koontz individually, right? That was the nature of.
I guess, are there any other than those two things, you would then concede he's covered under this statute, he'd be potentially liable for a deficiency judgment. Are there any other big picture differences that you're aware of?
I don't think so, not on the sequences I'm viewing it, of the facts that we're dealing with here. But if I could just make just a few quick points, I see that I'm running below 5 minutes. On these textual arguments, the appellant advances the claim that we're trying to graft statutory language into for the proposition that there is a personal obligation that is required by both of the definitions, consumer and debt. And that's certainly not the case. Appellant retreats to this position of saying these are remedial statutes, but that by no means gives this court, or appellant for that matter, the ability to rewrite the clear language of those statutes. This just came up in the Parsley case that appellant has relied on. Judge Chambers effectively scoffed at that argument and said, sure enough, this is a remedial statute, but, and I quote, the WVCCPA expressly limits its grant of civil enforcement suits to consumers. This court has no authority to rewrite the act. And then there's a suggestion, although it wasn't touched on at argument, but it is addressed quite in detail in the briefs relying on this court's case in Guthrie and the Second Circuit's case in Garfield, that SNSC is arguing that the bankruptcy code somehow entirely preempts or displaces the application of these consumer statutes, and that's not an argument that's been advanced at all. In fact, we've relied on a number of cases to offer distinguishing scenarios between, say, the Koontz case, the Fabian case, the Lovegrove case, where action under the FDCPA was not permitted, versus the Guthrie case, for example, which actually cites Lovegrove and the McGuire case in Croy. So suffice it to say, we're not advancing any claim of preemption or and displacement of these consumer acts by.
Can I ask you just a very, I don't mean to.
No.
But you're running out of time, so I just want to make sure I can ask you a somewhat peripheral question maybe about the state law claims here. So as the state law claims are in federal court on supplemental jurisdiction, is that right? Is that why they're before federal
Yes, yeah,
court?
that's
Okay.
right. They trailed with the FDCPA
Okay.
claims.
So once the district court dismisses the federal claims, there's a question about whether the district court should continue to exercise jurisdiction over the state claims or should dismiss them without prejudice so they can go back to state court. And there's a pretty strong presumption for not exercising jurisdiction over the supplemental or pendent state claims if you're dismissing at the motion to dismiss stage. Did this ever come up? Did the district court make a judgment here that notwithstanding that general rule, he thought it was important to go ahead and reach the state law claims? Did this?
He didn't, and I could only guess why that was the case. And my suggestion would be, Judge Harris, that they're so intertwined, share the same definitions, that the court decided that in one fell swoop, for the purposes, I suppose, of judicial economy, that dismissing.
Kind of a federalism foul, isn't it?
Yeah. And doesn't it sort of turn out that actually some of the state law claims don't fall under the same consumer definition?
Yeah,
So it seems like this was kind of a,
So I haven't examined the case law on the supplemental jurisdiction issue or the federalism question that it may implicate, but from practice, I've seen state law claims go in these consumer actions with federal law claims at the motion to dismiss stage all the time. So I'm not certain on that issue.
I was
but,
just wondering if it had come up, like, yeah.
There were a couple questions pending. I see that I'm out of time. I'm happy to address those or happy to rest.
I think we're good. Thank you very much.
Thank you all.
Judge Haytens, if I could turn to the Johnson case for a moment. I believe the language you quoted is really central to the argument that we're making. And I would also point out that what that language tells us is that a discharge doesn't eliminate the debt, it transforms the debt. It basically turns the debt from a personal liability debt into a non-recourse debt. And Johnson says that also on page 86, insofar as the mortgage interest that passes through a Chapter 7 liquidation is enforceable only against the debtor's property, this interest has the same properties as a non-recourse loan. So there is still a relationship between these parties. The note and the mortgage are the instruments that create the relationship, and they're the instruments that define exactly what the rights and responsibilities are growing out of that relationship. Lovegrove, Judge Harris, you mentioned Lovegrove and the disclaimers. I think it's important to point out the differences in those disclaimers. In Lovegrove, it was the typical disclaimers that you see. This isn't an attempt to collect a debt, and it's being provided for informational purposes only. But again, if we read the specific language in these two pieces of correspondence.
Then what was it? I mean, like, I get Lovegrove is Lovegrove, but on the other hand, it's an unpublished opinion, which we're not bound by. Like, I mean, we don't have to posit that Lovegrove was correct, because I read that, it's like, then why are you sending me this letter? Like, if that's not why you're sending me this letter, why are you sending me this letter?
And I think the reason they're sending the letter is made abundantly clear from the disclaimer itself. It's the first thing that your eyes see because it's in capital letters, it's at the top of the page, and it says that we're not attempting to collect as to your personal liability, and this is a step in enforcing our foreclosure rights. And that's clearly a demand for a payment and a threat that foreclosure will follow if
Just
that
because
payment
threats are
isn't
phrased,
made.
I guess, just because threats are phrased nicely doesn't mean they're not threats.
Exactly. And I would say a word about Obdusky. Obdusky said that an attorney who was participating in a non-judicial foreclosure is not a debt collector. That was the real issue that went up. But the court also said separately that where a lender or a servicer is engaged in foreclosure, that is debt collection. And that's the situation that we have here. We're talking about what a lender does, what a servicer does, and Obdusky stands for that very simple proposition. That is debt collection. And I would also point out that we're not trying to graft anything into the definitions of the FDCPA. The fact of the matter is, if you look at the definition of a consumer, it does not say personal obligation. What it says is obligation, either an obligation or an alleged obligation. And the Johnson case tells us there is an obligation here. There is an enforceable obligation that is, at its core, a non-recourse obligation. And because there's an obligation, Mr. Koontz qualifies as a consumer and is entitled to all of the protections and benefits of the FDCPA. Lastly, if I could address the state law claims, Judge Harris, I do not believe that issue was raised below, whether or not he should address those attendant state law claims. But I would point out that the judge made an error in deciding that those state law claims should be dismissed because he didn't apply the right definition. There are 3 claims that we've asserted in our state law claims that are not debt collection claims. They don't fall within those provisions of the West Virginia CCPA, and so they're not subject to that more restrictive definition that talks about obligation or alleged obligation. It's a much broader definition. Even SN concedes that the judge did not apply the correct definition, and so we would, at a bare minimum, ask that those state law claims be remanded to state court so that the judge can apply the right definition as a threshold matter. And unless there are any questions, I think my time has expired.
Thank you very much.
Thank you very much.
We will come down and greet counsel and then go on to our next case. All right, we will hear argument next in number 232235, National Association of Immigration Judges versus Neal. And Ms. Krishnan, when you're ready.
Good morning and thank you, Your Honors. May it please the Court, my name is Ramya Krishnan and I appear for Appellant National Association of Immigration Judges. I reserve 3 minutes for rebuttal. This case is about a sweeping prior restraint on the speech of federal immigration judges. Under the challenge policy, judges are categorically banned from speaking as private citizens about immigration law and policy issues that they are uniquely positioned to address. This ban inflicts what the Supreme Court in Axon Enterprise called a here and now injury. But the government argues that to obtain relief, judges must mire themselves in an administrative process that might never lead to federal court or else deliberately violate the policy and risk being fired. This is not and cannot be the law. The government has made 3 main arguments, each revolving in some way around the first and most important Thunder Basin factor, which asks whether withdrawing district court jurisdiction could foreclose meaningful judicial review of the plaintiff's claims. First, the government argues that the Civil Service Reform Act, which I'll call CSRA for short, provides meaningful judicial review of NAIJ's claims because the association can raise those claims through the statutory scheme. But this is incorrect. NAIJ can't obtain any judicial review through the scheme because it does not challenge a covered employment action. To start, none of the association's members face removal or any other adverse action covered by the scheme, and all of its members intend to comply with the policy. This means that none of its members can avail themselves of Chapter 75's review procedures. And they would fare no better under Chapter 23, which allows federal employees to challenge prohibited personnel practices. The government argues that NAIJ can challenge the policy as a prohibited personnel practice because it imposes a significant change in working conditions. But accepting this argument would require reading that phrase in isolation rather than as part of a whole, which the Supreme Court has instructed courts not to do. As the Fifth Circuit's recent en banc decision in Feds for Medical Freedom recognized, reading the phrase change in working conditions in context, it is clear that it refers to routine employment actions against individual employees, decisions like the decision to promote an employee or reassign an employee. It doesn't encompass broad prior restraints of the kind at issue here. This interpretation makes sense of the CSRA structure, which treats prohibited personnel practices as less severe than adverse actions and therefore worthy of less process. It's also consistent with a long line of cases which have allowed federal employees to challenge speech policies directly in court so long as they are not targeting a covered sanction for non-compliance.
So, but are these the cases that either predate Elgin, which some of them do, or are these, are the cases you're talking about cases that either predate Elgin or literally don't consider the very question we're here to decide?
The cases do precede Elgin, but Elgin, in our view, breaks no new ground here.
Really? Wow. When I read Elgin, I thought, wow, this breaks a lot of new ground.
Well, Elgin, I think what mattered in Elgin was that although the plaintiff employees styled their constitutional claims as a facial and as applied challenge, what they were really challenging in that case was their termination, which is a covered adverse action under the CSRA. And so the court held that, employees can't circumvent the CSRA by essentially, engaging in artful pleading, but that's not what's happening here. What plaintiffs bring is a simple pre-enforcement challenge that stands independently of any covered sanction for non-compliance.
I guess I'll say I read Elgin as standing for two high-level propositions. There's no facial challenge exceptionalism, so I think there's no pre-enforcement facial challenge exceptionalism exception to the CSRA. And I also read Elgin as saying there's no constitutional exceptionalism exception to CSRA. I think Elgin, to me, pretty clearly establishes both. There's not constitutional exceptionalism, and there's not facial challenge exceptionalism. And I put those two things together, and they seem kind of bad, because a lot of your arguments start to sound like either First Amendment exceptionalism or pre-enforcement exceptionalism. Why am I wrong about that?
So I think Your Honor is correct that Elgin says that it is not decisive whether you bring a facial or constitutional challenge. What matters is whether the employee is a covered employee and whether they challenge a covered employment action. And the policy that we challenge here is not a covered employment action like the adverse actions that the employees in Elgin had already suffered. But I would also point to the Supreme Court's most recent guidance in Axon Enterprise, which clarifies what meaningful judicial review entails. And what that case makes clear is that where the plaintiff is suffering what the court there calls a here and now injury, where they are suffering the kind of harm that cannot be remedied by post-deprivation judicial review, that they are entitled to immediate judicial review, and that's the kind of injury that NAIJ's members suffer.
So I'm glad you brought up Axon, because I will fully confess that until I read Axon and reading all the cases before Axon, and candidly, none of them make any sense to me at all. But then I get to Axon, and Axon's like this really helpful opinion. It basically says the basic question, we need to step away from these in the weeds stuff, and we take a step back. And there's Thunder Basin, where we say you got to go through the CSRA, and then there's Free Enterprise, which says you don't have to go through the CSRA. So the question we're going to ask in Axon is this a case that's more like Thunder Basin or more like Free Enterprise, right? And then the court gives a whole series of reasons why that case seems more like free enterprise. And the problem for me is that I grant your point about the here and now injury, and I want to get to that. But possibly with the exception of the language about the here and now injury, every single thing the court says in Axon about why those folks don't have to go through the CSRA, I read it and I go like, and that's a reason why these plaintiffs do have to go through the CSRA. Like every single reason Justice Kagan's opinion for the court gives, other than the here and now injury, points me in the direction of saying CSRA. Why am I wrong about that?
So I think this case is actually worse than Axon, because in that case, the court recognized that the plaintiffs had a guarantee of judicial review if they went through the statutory scheme, whereas here they don't. And when they talked about free enterprise, what they said mattered in that case was that although the accounting firm was mired in a board investigation, but not all board actions went to the commission, and the statutory scheme there only provided for judicial review of commission orders. And so the court held in that case that there was no meaningful judicial review, in part because the plaintiff firm then might never obtain judicial review by going through the statutory scheme, and that's what you have here.
You have to acknowledge there's lots of language in Axon that does seem to apply here, where the court's like, the reason these folks don't have to go through the system is they're challenging so like they're going to show up in front of the agency and they're going to say, I do not recognize the legitimacy of your authority. I shouldn't have to be here. I shouldn't have to be here. That's going to be their answer to every single thing the agency does. I shouldn't have to be here. I shouldn't have to be here. I shouldn't have to be here. There's no reason for us to talk about the merits because I shouldn't have to be here. And so, like, what's the point of going to the agency if the thing the person's going to say over and over and over again is I shouldn't have to be here? That's not true here. And there's like expert. And also, the agency is not an expert in whether the agency is unconstitutional. Like that seems like. But here. Like, there's a lot of questions in this case. I read the briefs and I was like, I don't really understand exactly how this policy works and what the details are and can we make it more reasonable. These all strike me as things that the agency would be exceptionally well suited to do. Like, what's the reason why we're trying to tell immigration judges they can't do this? And is there what's the reason for this restriction and how do we implement it? And all of those questions strike me as the heartland of what the agency is there for.
So what Axon says about the expertise factor is that the question is really whether the constitutional questions that are raised are intertwined with or somehow embedded in issues in which the agency, the relevant agency, is expert.
Yeah,
and in that case, the court held that there were no relevant threshold questions, that the constitutional questions that the agency there could moot. And you have the same thing here. I mean, the government has identified a single threshold question on which the board is expert. And this is something that distinguishes, for example, the Righty case.
I just want to make sure I'm understanding kind of the schematic here. In Axon, they're looking for whether there are these sort of threshold questions as to which the agency might be expert, because everyone is agreeing the agency obviously has no expertise on these separation of powers questions. But here, I would think the agency does have expertise on kind of the merits, the underlying merits. Like don't they see speech policies all the time and have to figure out whether those, I don't understand why the agency, forget the sort of preliminary threshold questions, the agency would have expertise on the underlying question here. What is the point of this policy? Why is it a good idea? How should it be applied?
So generally speaking, when the board has touched on First Amendment questions, they're always within the context of an individual employment action. And I can see that the agency has relevant and special expertise where what it's confronting is an individual employment action. But there are a number of textual indicia in the CISRA which strongly point to the conclusion that what change in working conditions refers to is typical everyday employment actions that are taken against individual employees. I mean, to start with, change in working conditions appears in a residual clause that comes at the end of a 12-item list defining personnel action. And the courts, when confronted with these kinds of residual clauses, have generally turned to the principle of adjustum generis and have interpreted the residual clause consistently with the preceding specifically enumerated actions. And all of the specifically enumerated actions in the personnel action definition are all individual employment actions.
So that's not how I read 11, but maybe people could read that differently. But the district court points to 11, I think, the implementation or enforcement of a non-disclosure policy. And that does sound like it's talking about a policy, and not only that, but a policy that bears on speech. Why is that not a problem for your argument?
Well, conspicuously, that Romanet refers to not a policy, but the implementation and enforcement of a non-disclosure policy. And I think that this language at the end of the definition of personnel action is also relevant with respect to an employee. And I think read in context, it's clear that that implementation and enforcement of non-disclosure policy is meant to read consistent with the rest of the definition, and all of the other actions mentioned are individual
So we should do
employment
use them
actions.
generous for 11 too, basically. To understand what 11 means, we should also compare 11 to 1 through 10 and read it to mean only individual actions related to this non-disclosure policy. Because when I see implementation of a policy, that sounds to me like putting out a policy. I've implemented a new policy for my office, and this is it.
I think if Congress had intended to refer to encompass non-disclosure policies or speech policies writ large, it could easily have said so. And it is notable that it did not, and this court should give effect to Congress's intent there.
So I have just a close the loop point on 11, I think. So when you said it says the implementation or enforcement of any non-disclosure policy, does that mean that your argument suggests that if a person wanted to just challenge the non-disclosure policy writ large, they can do that outside the CSRA? Like my agency just announces a non-disclosure. It's not how they implement it. It's not they enforce it. You think you could bypass the CSRA then too?
Where they haven't suffered a covered disciplinary sanction, and so the case would be distinguishable from Elgin in that respect, that it wouldn't be an attempt to use the proceeding to reverse what is a covered employment action. And this also makes sense of the structure.
It does? I was just literally about to say, to me, that seems to make complete hash of the statutory structure, because it turns out there are like, I'm hearing what you're saying is like, there are a million ways around this for anyone who wants to challenge any policy. You just repackage your claim as, I'm not challenging the thing that happened to me, I'm challenging the policy.
I mean, I don't.
It also seems to me that it reaches the opposite result of what you would want, that the person who's actually suffered injury gets, as you put it, mired in this agency review process, but the person who's actually not suffered an injury and just has a hypothetical claim takes their claim to federal court. So it seems to turn the whole system on its head, where you have the more injured employee in this more arcane process, as you called it, or the person who is just bringing this hypothetical claim with no injury gets to come to federal court. So how does that work?
I think for the mine run of employment policies, and then this is something that Judge Howell recognized in the Turner decision, that an employee is going to be unable to point to an injury distinct from a covered sanction for non-compliance that stands independently of the policy that they're challenging. Whereas here, what NAIJ challenges is a policy, the very existence of which causes a here and now injury because it chills speech, whether or not NAIJ's members are ever disciplined for not complying with the policy. And you simply won't have that with most employment policies.
What, because but I presume most policies are in fact designed to chill things. Like if I have a policy that says you have to come to work by 9 a.m., that is designed to chill people from coming to work after 9. The point of policies is to deter things that are prohibited by the policy. That's what the point of policy is, right?
But I think what distinguishes the chilling effect here is that we're talking about speech. And the Supreme Court and this court have made very clear in many, many cases that where a person is suffering even a temporary loss of their First Amendment rights in the face of a prior restraint, that is irreparable harm.
So, okay, so that is at least a principle. So this doesn't apply to everything. It doesn't even apply to constitutional claims generally, because this chill thing that you're talking about, we don't do this for most constitutional rights, right? Like, if I believe there's a policy that violates the Equal Protection Clause, or violates the Fourth Amendment, or violates the Second Amendment, this chill theory that you're advocating doesn't work, right?
That's correct.
Like, I don't know, a policy that says no firearms in my building. You couldn't bring up, is embracing your position saying a person who wishes to challenge the no bringing a gun to work can bring a pre-enforcement challenge against the no guns to work policy?
No, not at all.
Because of the First Amendment exceptionalism?
Becau-
But how would that be a personnel action in your view? How would me just saying no one brings a firearm into my office, how is that a personnel action in your view? Or someone would have to bring a firearm and then get fired, and then and then they could challenge it through this? Is that the idea?
I think that, when you're talking about a non-speech policy,
Right.
generally speaking, you only have a covered action where an employee suffers a covered disciplinary sanction. But an employee still, if they want to get into federal court, is going to have to satisfy Article 3 standing and ripeness requirements. And in most cases,
But that employee would say, I would bring a firearm to work, but for this policy that forbids me from bringing a firearm. And they attach a declaration, and there's no reason to question them that they would in fact do it. Don't they have Article 3 standing at that point?
Article 3 standing if they
If they
have
execute a declaration that said, my boss has a rule that no one can bring a firearm into the office, if my boss did not have such a rule, I would bring a firearm to the office, as demonstrated, if you want to really make standing belt and suspenders. In previous jobs where I was allowed to bring firearms to the office, I did in fact bring firearms to the office. So there's no reason to doubt my sincerity when saying that I would do it. That person has Article 3 standing. So the reason, if that claim loses, it's not because they lack Article 3 standing, right?
Can I have a moment
Sure.
to answer your Honor's question? I mean, this court's case in Righty suggests, for example, that where an employee, even short of having suffered termination, faces a covered adverse action, it may be that they're able to bring a pre-enforcement challenge through the CISRS review procedures. But I do think this ultimately comes down.
I just want to, is that how you read the CSRA, that someone who faces in the future the possibility of a Chapter 75 adverse action can bring a pre-enforcement challenge through Chapter 75? Because I feel like that would resolve all of your problems.
No, I mean, I think the adverse action would have to be proposed within the meaning of the statute. And in that case, the court thought the termination had been proposed because the employees had not only violated the policy, but, quote, enforcement had already begun. And we don't have facts of that nature in this case because NAIJ's members have complied with the policy, they intend to comply with the policy, and so there is no prospect of an adverse action.
I wanted to turn your attention to our unpublished opinion in Fleming versus Spencer. In that case, again, in an unpublished opinion, this court found that Chapter 23 requires administrative exhaustion, and that deals with the Thunder Basin issue under Chapter 23. So it is unpublished, it's non-precedential, but it seems to resolve the problem if we were to follow that case.
So I think two things, Your Honor. First, it's unclear to what extent that suggestion is consistent with the first Thunder Basin factor, which asks whether meaningful judicial review could be foreclosed by going through the statutory scheme. But I think, and this brings me to the other basis on which I think that decision can be distinguished, which is that the personnel actions in that case were undoubtedly covered by the scheme, and they were also what the court described as minor. And so I think it's conceivable that Congress intended to channel constitutional claims to minor personnel actions through the OSC review process. Query to what extent that's reconcilable with the Supreme Court's decision in Webster versus Doe and the first Thunder Basin factor. But this case ultimately is not that case because we're not talking about a covered action, and we're not talking about, even if it is covered, it's not minor. We're talking about a prior restraint, and the Supreme Court has said that a prior restraint is the most serious and least tolerable of infringements on First Amendment rights.
Can I just ask you, so you said earlier that this case is like free enterprise and that if this is covered by 23, there's no guarantee of judicial review. You might get it, but you might not, and that's what the court said in free enterprise was a problem. But it does strike me that there's some at least common sense appeal to the Fleming response to that, which is like, but you might get judicial review, so why don't you exhaust and see if you get judicial review, and if you don't, maybe now we have a Webster problem and come back to us then.
So the Supreme Court has never held that an employee is, or a plaintiff rather, is required to exhaust their administrative remedies under a statutory scheme where that scheme doesn't offer a guarantee of judicial review. And if the question was simply whether the plaintiff administratively exhausted, that really would just effectively write the first factor of Thunder Basin out of the framework, because that question, the answer to that question would always be no, because a plaintiff could always come back to district court after exhausting, and the court has never approached the availability of meaningful judicial review in that way.
I take your point that the court has never said that, but as the Supreme Court or this court in a published opinion never said the opposite. So I totally agree that if a statutory scheme basically guarantees ex ante that you will not get meaningful judicial review, you don't have to exhaust. But this is a situation where under this, like, it's almost like Schrodinger's, like, effective judicial review, because any immigration judge who doesn't like this policy may or may not get effective judicial review, because if something sufficiently bad happens to them, they are going to get judicial review. But we don't know that, right? And so has the court ever said that in that situation you don't have to exhaust? Has the Supreme Court or this court in a published opinion ever said in the Fleming situation that you don't have to exhaust?
No, it hasn't. But as I explained earlier, I do think the idea that a plaintiff just needs to administratively exhaust is inconsistent with free enterprise and the court's characterization of that case in Axon. Because I think if administrative exhaustion would have been enough in that case, the court would have said, well, just try anyway. Wait out the board investigation. See if you get the kind of sanction that you can seek review of through the statutory scheme. And notably, the court didn't say that. It found that the scheme did not offer the plaintiff meaningful judicial
Can I ask you to
review.
go back to something Judge Berner asked you, which is like the high level, how does this not just flip the statute on its head, which is to say that the person who gets the bad thing happen to them has to go through this administrative labyrinth, as you call it. The really bad things, if a really bad thing happens to you, you've got to go through the agency. But if either nothing has happened to you or only something minor has happened to you, you don't have to go through the agency. Instead, you can just go straight to federal district court, like taking a 10,000-foot overview, sort of like the court does in Axon. How does that not just like completely flip over the table on how this statute is supposed to work?
So, I mean, I think that as the Fifth Circuit recognized in Feds for Medical Freedom, the purpose of the SISDRA is to be comprehensive as to the claims that fall within its ambit. And that's claims that challenge a covered employment action. So it does nothing to serve that purpose to interpret the statute as stripping jurisdiction over claims that don't.
That doesn't really respond to the argument that the regime that would be created by adopting your rule seems wildly inconsistent with the sort of overall, like, music and lyrics, I guess music, not lyrics of this statute. Like, it just doesn't seem to fit at all with what this statute is designed to do.
Well, so I think two things. The first is, and I don't think this court needs to reach the hard question of whether constitutional claims challenging a minor personnel action of the kind that was at issue in Fleming is channeled or isn't channeled. I think that that's a harder question than the one that's presented in this case, where it is clear that what NAIJ's members are challenging is not even if it is a personnel action, it is certainly not a minor one. We're talking about a far-reaching policy that affects the speech of hundreds of federal employees. And I don't think, or I think rather that is considerably more serious even than a suspension or termination of a single employee, because all of these judges are having their.
But that sounds like an argument that there's an exception for facial constitutional challenges, and the one thing Elgin tells me is there is no such exception. That just sounds like a facial challenge exceptionalism argument.
Well, it's not an exceptionalism for facial constitutional challenges.
Or a challenge to broad-based, if something is sufficiently broad-based, fine, it sounds like an argument that if a policy is sufficiently broad-based, you can just get out of the statute.
I mean, I think this ultimately comes down to what here and now injury means. And I think, the court recognized in Axon Enterprise that really is an exceptional thing that most plaintiffs are not going to be able to show. But NAIJ is able to point to that kind of injury here because we're talking about really the paradigmatic kind of irreparable harm in First Amendment.
So can I just, one thing last on this. So there are, I believe, 96 federal district courts in the country, is that right?
Sorry, what was?
There are 96 federal judicial districts in the country, I think?
I'm not sure.
Yeah. Okay, so your argument, but just so I understand, there are hundreds of immigration judges. So under your argument, a single immigration judge could sue simultaneously in every single federal district court in the country challenging this policy, right? There's nothing that would stop them. Like, I know you filed this in EDVA, but there's no reason you had to file this lawsuit in EDVA. You could have filed it any place that they have like jurisdiction. So instead of all being challenged through the agency, we could create a situation in which different federal employees simultaneously challenge the same non-disclosure policy in federal district courts across the country, and they're not channeled to the federal circuit, so they're going to be channeled to all the regional courts of appeals, right? So instead of going to the MSPB followed by going to the federal circuit, the legality of policies like this will be litigated around the country and go to every regional court of appeals, which again, at a high level of generality, seems wildly out of step with the entire point of the statute.
I mean, the alternative is that these judges may never obtain judicial review through the statutory scheme. The special counsel has entirely unfettered discretion to decide whether to petition the board for corrective action
But Judge
or
Brinkman said the
not.
solution to that is if the special counsel is totally unreasonable, you can seek mandamus against him. Now, you might say, I don't know where in the statute that comes from. Fair enough. But I mean, that would be a solution to that, right? If the only problem is you can't guarantee the special counsel will take it to the MSPB, a more targeted remedy would be to limit the special counsel's ability to not do that.
I think that the first Thunder Basin factor, which asks whether there will be meaningful judicial review, or rather whether going through the statutory scheme could foreclose meaningful judicial review, that's always been applied ex ante. It's always been assessed in terms of can you obtain meaningful judicial review through the statutory scheme. And Axon makes clear that judicial review is not meaningful if you have to suffer irreparable harm while going through administrative proceedings to get it, and that's precisely what we have here.
Can I just ask you a question about that last point and the here and now injury argument you're making? So Axon says that, like, if your challenge is to the whole structure of the agency, it's like qualified immunity. It really can't be rectified after the fact. And I'm trying to figure out, is your argument about chilling effects, is it that it is a here and now injury of the sort contemplated in Axon because it's almost impossible after the fact to go back and remedy the period of time for which your speech was chilled? Or is it that it can never be rectified, period, because the whole point is you are not going to speak, there will not be an enforcement action, so there is no possibility. It's just sort of a logical impossibility. Those seem like slightly different things to me, but I may have not explained it well.
I think it's the former. You know, we can see that they could obtain prospective relief against the policy were they to ultimately end up in federal court through the statutory scheme, but it's that the federal circuit could never retrospectively remedy.
Why not? Why couldn't you get damages?
Well, we don't seek damages in this action.
But there is such a thing as damages for speech that has been chilled in the past, but maybe this particular statutory scheme doesn't make those available, is that?
Well, I think even this court has recognized that the kind of speech harm that we're talking about here isn't remediable even by damages. I mean, speech is just...
Like, we have cases about this saying, like, if you can show that your speech was chilled through, you have a reasonable fear of repercussions in the past, and there's something specific, you would have said, you can get damages for that.
I think that this court's case law on applying the irreparable harm prong of the preliminary injunction test is instructive. This court has routinely found that the kind of harm you suffer at the hands of a prior restraint that really is per se irreparable harm, and the court has applied the Supreme Court's guidance in Elrod versus Burns.
But that doesn't really work, because now you've just blown up your First Amendment exceptionalism theory, because we've also said that basically the deprivation of any constitutional right is per se irreparable harm. So that is if that's the response, then we no longer have a First Amendment exceptionalism argument. We just have a constitutional rights are different argument, and that brings me back to Elgin saying constitutional rights are not categorically different.
Well, I mean, I think what Axon asks, and this is the language the court uses, is whether it's the kind of harm that can be undone. And the harm that judges suffer in terms of judges not being able to engage in private capacity speech now on matters of urgent concern because the policy forbids them from doing that, judges who seek continue to seek pre-approval, but only to speak in their official capacities, meaning that the agency has a veto over what they can and cannot say. Judges who face delays or sometimes do not get a decision at all when they do seek pre-approval from the agency. None of that can be undone by post-deprivation federal circuit review. There are judges right now who want to be able to speak at events and are being precluded from doing so. And the federal circuit, if judges ever get there down the road under the statutory scheme, and I think it's extremely unlikely, would not be able to enable those judges to speak at these events.
Why is it unlikely that they would get there under the statutory scheme? I actually think it's highly likely that the OSC would bring the case because there's an allegation of a constitutional harm. I think it's unlikely that the OSC would decline to take it, and they would take it to the MSPB, and then it would be appealable to the federal circuit. So it seems it is likely. And following just on Judge Hyten's hypothetical of 96 cases going to different federal district courts, I would venture to guess that many, many agencies have a speech policy that limits the speech of the employees of the agency and requires them to go through some kind of review prior to public speaking. And so it's not only that there could be 90 some odd cases challenging the same policy, there could be cases challenging every policy of any federal agency brought to federal court rather than to the agency to the single agency. So you could have, rather than a patchwork of policies around the country, a single policy governing all of the employees at that agency.
So to Your Honor's first question about the likelihood of getting judicial review through the OSC process, to start, and this goes back to the language of the first Thunder Basin factor, it's whether going through the scheme could foreclose it, not whether it definitely would. But more than that, the special counsel's, and I think this is instructive, reports from the last 5 fiscal years show that it has never once petitioned the board for corrective action. That has never once happened in the last 5 years. And that's strongly suggestive that going through the OSC process is unlikely to result in judicial review. But to Your Honor's second concern, I mean, I think if federal agencies, if there are numerous federal agencies with a kind of equivalent gag order we're talking about in this case, which are prohibiting broad swathes of federal employees from engaging in First Amendment protected speech on matters of urgent public concern, those employees are entitled to immediate judicial review. This is a very serious infringement of First Amendment rights that we're talking about.
We have kept you way too long. Thank you very much for your patience.
Thank you so much.
Good morning, Your Honors. Jennifer Utrecht on behalf of the government. Your Honor, the CSRA is an exclusive and comprehensive regime that precludes district court jurisdiction for all covered personnel claims that fall within the scope of the statute. At bottom, plaintiff's argument here is that their claim is different and falls outside this exclusive regime, either on one of 2 theories. One is that there's somehow an exception for preemptive challenges to policies that will impose discipline, and the other is that there's somehow an exception for First Amendment challenges. Neither of those sort of carve-outs are supported by either the text of the statute, and in fact, they're contrary to the Supreme Court's decision in Elgin, and would flip the actual operation of the statute on its head in a number of ways. So first, as Elgin recognizes, the CSRA was designed so that there would be a uniform body of federal law that would govern personnel actions involving discipline, involving the changes in responsibilities, duties, and working conditions that violate the Constitution. If plaintiffs were correct that they could bring district court cases before any discipline had been initiated, that would completely dissolve this ability to have a uniform body of case law. There would be district court cases throughout the country addressing the constitutionality of the same federal policy governing the same federal employees. It would completely overturn the uniformity that Congress intended through the CSRA. The second way that plaintiff's proposal would flip the statutory scheme on its head is that it would create a system where individuals who are, in some respects, the least injured, who had not had any discipline imposed on them at all, would be able to proceed in district court, whereas those who had in fact been terminated or suspended or had a reduction in pay would have to go through the administrative steps. That's precisely contrary to the way that Congress intended the statute to operate. It also creates potential parallel jurisdiction problems. I know that plaintiffs here have asserted in their complaint that they do not intend to violate the statute, and that is the reason that or the policy, and that is the reason they believe they can proceed in district court. But the fact of the matter is, if someone were to violate the policy, would they then be able to proceed both in the MSPB and in the district court? I mean, these are the sorts of concerns that Elgin articulated as to why constitutional challenges, no less than other types of challenges, have to be channeled through the CSRA's regime.
Can I ask you a threshold question that's been bothering me since I started looking at this case and all these cases? What is the underlying waiver of sovereign immunity here?
I'm
This
sorry.
is a lawsuit against the federal government. So I start with the premise you can't sue the so the Thunder Basin even says it's whether it withdraws 1331 jurisdiction, but then it's this is a suit against the United States. So therefore I need to 1331 is not a waiver of sovereign immunity. So what's the waiver of sovereign immunity here?
So we haven't, I mean, it's possible that sovereign immunity would be a separate jurisdictional problem. We haven't really addressed that here, in part because the district court held that the CSRA preclusion is it divests it of subject matter jurisdiction. I mean, it is clear that Congress, through the CSRA, articulated a specific scheme whereby
Sure,
federal
I'm just saying,
employees could challenge.
in general, if a person wants to go into federal court and sue the federal government, they need a waiver of sovereign immunity. Although I guess technically, maybe this is just ex parte Young. The federal government is not the named defendant in this lawsuit, so this is effectively an ex parte Young action.
Certainly not something we'd briefed, and I wouldn't want to get out ahead of the government's position on this issue. I would say that I think this is a common question in sort of these implied First Amendment actions.
Okay. So can I just, at a high level of generality, my hypothesis is that people who drafted this law were simply not thinking about constitutional challenges. It seems fairly clear to me that they weren't. So let me just ask you, so let's put aside the employee who doesn't violate the policy. Let's talk about the employee who gets what I'll call low-level discipline. Let's talk about, not fired, the low-level discipline person. So let's say a person violates this statute and gets low-level discipline, and they say that low-level discipline violates the First Amendment. Okay? Let's just posit all that. Say that I believe that constitutionally speaking, that person has to have a mechanism to get to federal court. A person who claims that their federal employer violated their First Amendment rights and did a bad thing to them as a result of that has to be able to get to federal court. The problem, I say, is that the straightforward reading of the statute is there is no way to guarantee they can get to federal court. So I can do one of two things in response to that. One, I can basically force the special counsel to do the thing that will let them get to federal court, the sort of mandamus approach. Or I can let them go straight to district court. But that constitutionally, they have to be able to do one of those two things. Does the government have a position of which of those two things it should be?
I'm sorry, the order was, the first one was that they have to force the special counsel.
Well, so it's the thing that
second
Judge
one was-
Brinkema basically says. Judge Brinkema responds to this by saying you could effectively, in that situation, a court could, in an extreme situation, force the special counsel to commence a series of events that would culminate in them being able to go to the federal circuit. I don't really know how the statute says you can do that, but I think it's against a backdrop of it cannot be the case. Congress is not allowed to say that a federal employee who says that something bad happened to them in violation of the First Amendment has no mechanism of getting to federal court. And so how would you go about doing that?
Well, so I would say that we would look at the CSRA, which, as Your Honor's question notes, provides administrative options for that claim to be raised that would get judicial review if the special counsel.
There's this hammerlock where the special counsel can stop me from going to federal court.
So as to that point, Your Honor, I understand that the premise of the question is that you have concerns with that, but I mean, this court's decision in Pinar versus Dole, the logic of Elgin, the DC Circuit's decisions in AFG versus Trump and Secretary of the Air Force, the Sixth Circuit's decision in Craster, they all reflect a basic principle, which is that Congress can decide that there are certain, low-level things for which there are administrative protections, but no possibility of judicial review.
Let me just posit, outside the realm of constitutional rights, I think that absolutely makes perfect sense. Congress can, if I put a reprimand in someone's file for doing something bad, I think it's, and assuming that there's no allegation that that violates the Constitution, it's just the person thinks it was really, really wrong, or really, really arbitrary, or really, really unreasonable, or really, really unfair. I agree, there is no constitutional problem whatsoever with saying that person has no way of getting to court. But I'm saying when it comes to the allegation that the federal government violated my constitutional rights, that is different, and you cannot say that person can't go to court.
And as to that point, Your Honor, if that's your concern, then I think that the alternative exhaustion problems are a way to handle this case. That plaintiffs have not attempted to go through the special counsel, that we don't know how the special counsel would handle that. And the special counsel, whose very job it is to investigate these personal practices, who operates independently and is supposed to correct these things, has every incentive to both work with the agency to correct potential constitutional problems even before an MSPB complaint is filed, and to file MSPB complaints. And if it comes to pass that neither of those things happen and there continues to be a constitutional problem, then perhaps we can address the Judge Brinkema question of whether sort of a mandamus action might be appropriate in that instance. We're not presented with that here because there has never been an invocation of those procedures by these plaintiffs.
Could you give me an example of what you think the agency's threshold expertise is here? You say in the brief that the agency has threshold expertise. As applied to this specific policy, what is a tangible example of where you think the agency would have expertise?
Sure. So there's three things I think I'd like to point out here. The first is, as Elgin recognizes, the MSPB routinely deals with claims of
I don't
First
want
Amendment
high-level
violations.
generalities. I want a specific example of what you think the agency
So,
is expert about.
well, and that's general point. It routinely deals with these things, which means that it routinely deals with, as would be relevant to this policy, both developing a factual record in terms of how the agency is actually applying the policy. And if you look at the plaintiff's complaint, there are some allegations about how the policy is being applied that on the face of the policy don't seem to be actually what the agency is required to do. There would be factual disputes about that. There would be development of what the need for the policy is, how common this is, which can reflect on how important it is for the government to have this sort of restriction. All of these sort of threshold factual questions go directly to the Pickering balancing test that would apply with respect to the ultimate constitutional question here. And those are the sorts of things that the MSPB deals with all of the time. And
I guess including what was the perceived need for this policy, because potentially I guess the agency could say before we had this policy, we had employees who were going off and doing things that were ostensibly speaking in their personal capacity, but sure seemed to be speaking in their government capacity and sure seemed to be saying things, so stuff like that, why we adopted this policy in the first place.
Exactly. And I also note, Your Honor, part of the congressional delegation of authority to OSC is, before an MSPB complaint is filed, to work with the agency after it's investigated, to try to correct the problem before a complaint is filed. That's part of the special counsel's job. And so there is an expertise there as well. It's both investigating the complaint, working with the agency, proposing solutions. These are the sorts of things that as a practical matter happen before an MSPB complaint is filed, and certainly before judicial review would come into play, before the courts are asked to weigh in on this.
So can I talk about NTEU briefly? So is the government's view there wasn't actually jurisdiction in that case? It's just that no one somehow managed to notice that there was never jurisdiction in that case at all? No one picked up on the fact that there was no jurisdiction in that case?
As is the case, I think, in many older Supreme Court cases, jurisdiction was not addressed by the court at all.
So the answer to my question is yes?
I would have to do a deep dive into the procedural history of that case, but
No, I don't mean how it happened.
Yeah.
The government's view is there was, in fact, no jurisdiction in NTEU.
I think that's the right answer based on what the Supreme Court has said in Elgin and what this court and other courts of appeals have said about CSRA channeling since the Supreme Court's decision in Elgin.
Can I ask you just a question about how much it matters for your argument that this is a covered action under Chapter 23? Because I understand your argument to be, first, we think it's covered, but second, it really doesn't make any difference, because if Congress doesn't want to cover it under 23, that's fine, and they're just channeling it to post-enforcement review under Chapter 75. So does it matter to your argument whether it's covered?
So it matters in the following way. So Your Honor is correct that our bottom line position is that if Congress has directed that something be channeled through post-enforcement review, and there's judicial review at the end of that, that's sufficient. Elgin makes clear that that's sufficient. Where Chapter 23 comes into play matters in two respects. The first is that it shows that Congress did contemplate some sorts of limited pre-enforcement challenges. This isn't something that is, an anomaly. We know that Congress thought about this. It prescribed the limited ways that this could happen, which means that this isn't an oversight. And if plaintiffs' claims fall outside of this limited review, that is the scheme that Congress designed, and courts have to give effect to that. The second way that it comes into play, Your Honor, is that Chapter 23 also provides clear statutory exceptions to the OSC process, one for employment discrimination that's prohibited by other statutes. If those statutes provide direct review to the MSPB, the Chapter 23 permits that. And the second is for situations where an employee claims that they were retaliated against for whistleblowing or for refusing to comply with an order that would require the employee to violate a law. And those also, the employee can file directly with the MSPB. And what that shows is that Congress knows how to create exceptions. It did not create an exception for the type of claim that plaintiffs want to bring here that would allow them to bypass the special counsel process. All that shows really goes to the comprehensiveness of the CSRA and reinforces the point that district court jurisdiction is precluded over this type of claim.
So you have like maybe an even stronger argument if this is a covered practice or a covered thing under Chapter 23, but I do understand like almost the main point in your brief to be, well, who cares? Because even if it's not covered under 23, Congress can channel it into post-enforcement review under Chapter 75. And I guess I'm totally understanding that, except with respect to this particular injury, because I do get caught up in this question. Well, even if Congress can mostly do that, how can it do that if by definition we're talking about a cognizable constitutional injury? The court has said this a million times, like chilling effect, that counts. That's a First Amendment violation. But it is one that by definition cannot be reviewed post-enforcement because there will be no enforcement because the speech is chilled. Then it seems like you are just saying, I guess this goes back to Judge Heitens' kind of first premise, like, and in those cases, there will simply be, you can have a broad speech restriction. No federal employee may ever criticize the president in public, and it simply will not be subject to judicial review, and that strikes me as like kind of a non-starter.
Well, as to that, Your Honor, I would note that although plaintiffs have sort of characterized their claim as being divorced from the sorts of things that are covered under Chapter 73, if you look at the allegations, they really are inextricably intertwined with the kinds of discipline that would be covered by Chapter 23. The basis for their standing.
I totally understand your argument that it is covered by 23.
Or sorry, 75. I'm sorry. I meant discipline under 75. Because if you look at the allegations of their complaint, their basis for their standing, this theory that their speech is being objectively chilled, is because of the threat, as they note in the complaint. I think it's paragraph 20 in the first paragraph of the complaint.
That's just First Amendment doctrine. There's a law out there. It says if anybody in the world criticizes the president, they'll go to jail. Like, I point at the law, I say that's what's chilling my speech, but I'm not going to do it because I don't want to go to jail.
And in most contexts,
right, Supreme Court said a million times, fine, we'll review it on its face pre-enforcement.
So, two more points. One, again, with respect to the complaint, what they are asking for here is to prohibit enforcement of the policy, to tell the agency that they can't impose the discipline.
Right, that's what I would be saying.
Yeah.
Just imagine a statute, it's a criminal statute that says you can't talk about, nobody can talk about immigration policy in public. From now on, we're just not having that as part of the public dialogue. I could, as of today, go to court and say that thing is chilling my speech. I want to speak about immigration policy, now I can't. And nobody would think, well, that's weird that you can get review of it before it's enforced against you. That's just First Amendment doctrine.
So I don't mean to be frustrating here, but I think the core distinction here is that I don't think we would be in this courtroom today if there was a policy by EOIR that said it would be really nice if you asked for supervisory approval, but it's not required and there's no enforcement action against you.
well, then there's no chill.
Right.
Right. Well, so what I mean to say, Your Honor, is that their theory of injury, the chill, is directly related to the sorts of things that are covered by Chapter 75. They are trying to jump the process. And the other point, Your Honor, and I understand that there is this concern, that emanates throughout First Amendment case law. It would be very difficult to create this carve-out without calling into question all sorts of ethics policies, which could in some way be characterized as being about speech. There are, as our brief notes, Department of Justice employees broadly, as EOIR immigration judges are subject to a whole host of ethics regulations that govern financial disclosures, that govern, prohibited sources of payment, those sorts of things.
Or take Romanet 11, which is literally about non-disclosure policies, every single one of which implicates speech.
And that is something that Congress said has to be
Right,
channeled through the special
yes,
counsel.
That was a friendly question.
And so, these sorts of concerns echo throughout government policies. Congress intended for these sorts of concerns to be raised either in post-enforcement proceedings or through the special counsel process. And the fact that these sorts of concerns were contemplated, that Congress created procedures that lead to judicial review, shows that there is no jurisdiction in district court over these kinds of challenges. And I appreciate the concern that the plaintiffs have expressed that there, in a hypothetical world, may be some way in which they go through the process and don't end up in a federal court. We're not there. We haven't even initiated those steps.
If it's covered by 23, you think, then we don't.
I also want to be very clear. I mean, the question of whether it's covered by Chapter 23 really is a question for the special counsel. That is the kind of thing the special counsel addresses when it makes determinations about whether to investigate and file a claim. And if the premise of plaintiffs' argument is that individuals can sue in district court claiming that something actually isn't covered by 23 before they go to the special counsel, we are going to have this problem of 90, I believe the number was above 90 district courts weighing in on what counts as a significant change in duties, responsibilities, and working conditions that may have differing views from the special counsel, the MSPB, and the federal circuit on that. That's the sort of thing that Congress wanted to avoid when it created the CSRA. If there are no further questions, we would ask that you affirm.
Thank you very much.
Your Honors, just a few quick points in rebuttal. Judge Hyden's on your question of sovereign immunity waiver. I think the answer is ex parte Young, because we seek only injunctive relief for an alleged constitutional violation. On the government's argument of suggestion that the scheme provides for meaningful judicial review, even if immigration judges have to violate the policy in order to get it. I think that's directly inconsistent with the Supreme Court's decision in Free Enterprise, which says that you don't have to bet the farm to get judicial review, and that if you do, that's not a meaningful avenue for relief. And the implications of that argument are startling. The current administration or a future one could issue a regulation requiring all federal employees to declare their loyalty or to abstain from all criticism of the administration and its allies. And employees would only be able to seek judicial review by risking termination and violating that regulation. And I don't think that's the law. The government's more aggressive argument that if the statute does not provide for judicial review, that's simply a deliberate congressional choice. I think that's directly inconsistent with the Supreme Court's decisions in Thunder Basin and Elgin, which recognized that a serious constitutional question would arise if a statutory scheme were interpreted to foreclose all judicial review. And that's precisely why the Supreme Court—
Foreclose all judicial review of what? You would agree for non-constitutional claims, there's no problem with that, right?
That's correct.
Okay.
Yeah.
It's a serious constitutional problem to foreclose all judicial review of non-frivolous constitutional claims.
That's right. And on this question of whether you can get administrative exhaustion at the end, I mean, notably, the government in its briefing at least suggested that NAIJ's members and federal employees generally would not be able to raise their claims in district court, even if they were unable to get judicial review of a colorable constitutional claim through the statutory scheme. But I also just think that this idea that administrative exhaustion is sufficient is at odds with Thunder Basin itself. You would have expected the court in that case to say that a plaintiff could simply come back to district court if they were unable to get judicial review through the statutory scheme.
So I hear you on this and on the whole, I guess really the district court's holding, and Fleming, and I understand sort of the conceptual issues you're raising, but I guess I'm thinking about almost more as a constitutional avoidance kind of thing. I do understand your point about the serious constitutional questions that would be raised if we adopted at least part of the government's position, which is, well, maybe you will never get judicial review, and that's okay. That was Congress's choice. But we don't know that we have that constitutional question in front of us because it is quite possible, as Judge Berner kind of outlined, that if you raise this, special counsel will bring it to the board and then it will go to the federal circuit. And so it feels somehow, just as a question of kind of constitutional avoidance, somewhat premature to weigh in on what would happen in that scenario.
Could I have 30 seconds to answer
course.
Your Honor's question? I think that, Thunder Basin and Webster, well, Thunder Basin and Elgin are clear that the constitutional question arises if by forcing a plaintiff to go through a statutory scheme that could foreclose judicial review. And that's precisely why the court in Thunder Basin framed the first factor as it did, with the emphasis on could and not would.
Do you have a question? All right, thank you very much. We will come down and greet counsel. And then we're going to, I will ask, after we greet counsel, we'll do a short recess. Return to our third case.
This honorable court will take a brief recess.
Please be seated, and we will hear our third and final case now, number 23-1716, Jose Mendez Guevara versus Garland.
Good morning, Your Honors. May it please the Court. The primary question in this case is whether an individual that states that 99% of the asylum claims filed by citizens of Mexico and the countries that make up Central and South America are utterly baseless is allowed to serve as a neutral adjudicator. And we would argue, Your Honors, that where we have published statements exhibiting bias against individuals of specific nationalities, that structural error compels remand to a new immigration judge. This is the same reason, for example, if we were to find out about a bias that was drawn out during voir dire, we would excuse that juror for cause. If these statements were made, for example, if we had jury trials in an asylum case, if an individual made statements of this particular tenor, we would strike that juror for cause. Also, after trial, if we found out that that individual who served on a jury had been able to hide some preconceived bias or had expressed racial animus against the type of race that the defendant was, we would also return that for a new trial. And so that's...
So this has nothing to do with the merits of the claim you're making currently. It has to do with the exhaustion of the claim you're making currently. So you point, in asserting that this bias claim was exhausted before the board, you point to JA 90, where you have a section about bias. So then I read that. And what that says, essentially, is the decision against my client was so unwarranted and so unjustified as to establish that the person was biased against him. But I don't see anything about his public statements. I don't see anything about the things that a person said when they're not in their capacity. It seems to me that to the extent a bias claim was exhausted, it was a bias claim that the decision itself, within the four corners of the decision, evidences bias. But I don't see anything about any claim of bias that's outside the four corners of the decision. So why is this exhausted?
So, Your Honor, I would point to two things. One, this own court's precedent, and I'm going to butcher this name, in Actingmon, basically says that if you argue bias in one way that, because we happen to use maybe a different argument to support that this individual was biased, we're not necessarily precluded from that. The second
This
thing...
seems to be, okay, give me the second one.
So the second thing I would say, Your Honor, is that the board dealt with this, and there's significant case law from both this court and several other circuits, Your Honor, that where the BIA directly deals with it, that has not been waived. And so given that the board in its decision on the motion to reconsider, they sort of faulted us, Your Honor, for that same reason that you did, that it wasn't brought up in the initial appeal that was handled by prior counsel, but then they said, and anyway, we're going to go ahead and deal with that.
So why isn't that an alternative holding?
I think because they dealt with the facts itself, that means that it hasn't thus been waived, since they did give their reasoning for why that wasn't sufficient, Your Honor.
I mean, it seems slightly, I know the cases you're talking about where we say, look, if the BIA dealt with this at like significant and sufficient detail, that there are circumstances under which we would say it's not forfeited. But the fact that this was on reconsideration, it does strike me as slightly different. I mean, I think if there's one thing that's clear from the BIA's kind of internal law and procedures, it's that you're really not supposed to be able to take your best shot before the BIA the first time and then come in the second time and say, same claim, but we've got a bunch of new evidence we want you to look at. And I am very nervous about sort of endorsing that kind of a trickling out the evidence as you go through with your claim.
I understand that, Your Honor, but I would point out that prior counsel did make, on the page that Judge Heitens was referencing, they did, as part of their bias argument, they made that the termination itself exhibited bias. And so part of our argument in the motion to reconsider was that one of the reasons that the EOIR decided to terminate this individual was because they were aware of the bias. Obviously, we don't have that in the record evidence because we couldn't get that, but they were just claiming that, it's protected by employment practices. But we, again, think that that is sufficiently preserved through their arguments about the termination of the individual and also the statements of the bias itself being present in there.
Can I, just as long as we're talking about kind of the stages at which the evidence is coming in, so in your introductory statement before us and in your brief, the statement you're relying on mostly to show the bias is the IJ saying that 99% of these claims are utterly baseless. But that statement was never in front of the BIA, right? That we're hearing about that for the first time on appeal.
I agree, Your Honor, and I know that the government disputes that, but I believe that that's sufficient enough for remand because, I mean, that didn't occur until we were well late into this stage. And so if the court believes...
I thought that happened you're telling me that that statement was made before the BIA made its decision on reconsideration?
Sorry, Your Honor, I might have been referencing the congressional hearing which took place during the briefing of this.
Right, the
So-
99% statement, I think, was available before the BIA made its decision on reconsideration.
Yes, Your Honor, but I also think that the sworn statements, especially given that they're under oath that were made to Congress, also,
Okay, but then I just wanted the 99% statement, that, we are hearing about that for the first time on appeal, even though it would have been available to have been introduced to the BIA on reconsideration.
that's correct, Your Honor, but
So I think we can't look at that because we are confined to the record that was before the agency.
well, I guess I would dispute that a little bit in the sense of like, is bias, to me, is a legal finding, and given that we're citing his published statements that are available to the court, because the BIA itself, it can't engage in factual findings, so bias must therefore by itself be a legal conclusion here. And so I think that the court can consider these statements. And again, if the court were inclined to say that, okay, at the very least, we need to put the congressional statements that were made during the briefing of this case before the board, then they could remand to the board to consider those congressional statements that, again, were made under oath.
So like, you're saying we could almost take judicial notice of this as a legislative fact? Like, he just said this in the world and we can notice it?
I think the court could take notice of a judicial law review article. I think the court could take judicial notice of published articles that came out from, news agencies, that kind of stuff. And so, again, if the court doesn't want to engage in that in the first instance, I think that remand would be appropriate in this so that it was properly before the board. Given that we're talking about an individual who made statements of a similar tenor both before and after his tenure of being an immigration judge, I think when presented with the sandwiching of that, I don't know how you can't conclude that he wasn't sort of the same mind at the same time that he was on the bench, Your Honor. And so I know that the government's arguing that this has to be contained within the four corners of the decision itself. I would argue that there are facts that are specifically overlooked by this immigration judge when he is designing to make a negative credibility finding. And the reason that it's so important that it's a negative credibility finding is because we give so much deference to that particular individual. We give so much deference to the fact finder on demeanor, on all these other things, and that's why we have a substantial evidence standard of review at this particular stage of appeal. But if you look at page 380 of the record, there's specifically a passport photo that is stamped with the date of June 29, 2015. Okay, in the IJ's decision at page 169 of the JA, he specifically faults them for not having included a stamped copy of the passport and then goes through like, oh, they submitted this other passport, but he's saying it doesn't have the stamp. But the IJ clearly never referenced the actual passport that was submitted because there's a clear stamp that's on page 380. In addition to that, he says that they didn't have letters from the family themselves, when if you go and look at the record at page 890, I believe, there was a letter from Saul, from Clelius' brother, that's included there. He said, we don't have a letter of evidence of anything from El Salvador that could sort of corroborate the events that you're occurring. So he faults him on credibility and corroboration, but then he fails to actually take full consideration of the record because he had in his mind that he was going to make a negative credibility finding, knowing that's the hardest to overturn on appeal.
Can I just ask you, so the BIA, as you say, they didn't, on reconsideration, did not just rest on, look, we're hearing about this for the first time. They also did rely on that statement from the board opinion that says an applicant is not denied a fair hearing merely because an immigration judge has a point of view about a question of law or policy. Do you disagree with that as a statement of law, or is it your position that there's something else here besides the IJ's point of view about a question of law or policy?
So I fully believe that immigration judges can speak on policy, they could speak on immigration reform, they could speak on one side of the issue or the other, and that would be completely fine. What I think is problematic here is when we're talking about a particular class of individuals that appear before the immigration judge as applicants for relief. And when he's called those baseless claims for relief, I think that's where it becomes a problem. I think if he just said at large, asylum needs to be reformed, these are things that I would think about restructuring, or we need border security, I have no problem with that, and I wouldn't be filing a motion to recuse here in this case. Similarly, there are many immigration judges I peer of in front of that were fierce DHS prosecutors and obviously took a very heavy enforcement position at their prior job, and I've never filed a motion to recuse against them because if they had just taken a simple policy perspective and not commented on individual cases or made sort of individualized predeterminations about outcomes, I don't think we would have the same issue that's present before the court today. And I would also note that I think that the board is violating its own principles. If you go look at matter of YSLC, in that case, the board doesn't actually make a prejudice finding. So the government argues that we haven't argued prejudice sufficiently here in this case, although I think, again, in a structural error, that should be presumptive. But YSLC never makes an actual deprivation, prejudice claim. And so they just basically said, this doesn't rise to the high level that we hold an immigration judge to. And as a supervisory authority, the board is able to impose a higher sort of set of ethics on its own employees if it wants to. And so I think we've satisfied at least the very appearance of impropriety and bias in this case. And so the board is then not satisfying its own standard, strict standard that it holds immigration judges to. And so, again, we're not asking for a broad rule here. We're asking for just specific remand in this specific case because of the nature of these specific statements.
Could I turn you from the bias question to the merits question, the sort of part where you're attacking the merits of the IJ's decision for a minute? I'll just say this. So I read the section of your brief about this, and I saw lots of things that strike me as totally good arguments for why there was a very good argument the IJ should have found otherwise. There's reasons that the IJ should have reached different conclusions, that there's innocent explanations for the things the IJ declined to give innocent explanations. But as you know, you do this for an area of living, that isn't nearly enough to get an IJ decisions credit, assuming, again, we get past the bias, bracketing just for the sake of argument. What is your sort of best case, or what finding do you think is your best case where it's not just the IJ should have, could have, probably, maybe would have, other IJs would have found differently, but that this IJ's finding was such that no rational finder could have concluded those things? Not just you believe they should have found differently in your case.
Well, again, Your Honor, I would point to the IJ's own factual findings as he's going through criticizing them on credibility and corroboration on page 169, that finding that there was no passport submitted that would have corroborated the entry date. Again, there is a passport in there that shows the entry date of June 29, 2015. He says that we don't have evidence from El Salvador. There was a letter from the brother who was still in El Salvador. And so I think that is sort of the best evidence because he's been cherry picking the evidence. And so then again, the board itself cites Anderson for the premise that, well, we might have two permissible views here, but we have to go with the view that we give deference to. And that, to me, suggests that the board was thinking, okay, if we didn't have to give deference here, if this was sort of de novo review, they might have made a different credibility finding. And I would also, I know it's
But the board's allowed to do that, too. The board itself is allowed to defer to IJs about credibility findings, right?
1,000%, Your Honor. But the problem is we can't defer to this particular IJ's findings because it's a negative credibility finding. For example, if he had just made a legal conclusion, I think that the board could have either obviously reviewed that de novo.
Wait, we can't defer because of the bias issue?
I agree. Yeah.
That is important because I guess you could view you as having two arguments. One is the bias argument, the other is the sufficiency finding. But I think, I want to make sure I'm not putting words in your mouth. So do you think that if for whatever reason the bias claim fails, bracketing that, assuming that you're not giving anything up by positing that for purposes of this question, do you have a separate claim that is independent and separate from the bias claim?
Yes, Your Honor. On the credibility, the holes we pointed out in the immigration judges and the flaws in his actual factual findings on credibility alone merit remand. But again, our position is that you don't get there, but if you do get there, we think that there's still sufficient evidence that he overlooked purposely parts of the record that would merit remand. Unless the court has any other questions. Thank you.
Thank you very much. You've got time on rebuttal.
Good morning, Your Honors. Spencer Schuchard for the United States. May it please the court. Petitioners in this case, I'm going to start with credibility because we believe it disposes of everything. One, because it's not exhausted, as you pointed out. Also because it shows there's no prejudice, and it's just not needed. Their credibility arguments are the same as their bias arguments, with the added gloss that, it's just an ad hominem attack there. So, petitioners in this case told the agency a story about how they were extorted and intimidated and kidnapped in El Salvador, but they couldn't keep their story straight about whether they ever called the police, about why they didn't make an extortion payment, about why they did turn around and make a large ransom payment, and critically, whether or when there was ever anyone who needed to be ransomed. And collectively, as they were doing this, they exhibited behaviors that the IJ reasonably found suspicious, including an inconsistent inability to answer basic questions. The agency can deal with credibility issues, quote unquote, as they see fit. That's from Herrera Alcala. So long as their disposition is tied to specific and cogent reasoning,
ask you just a question about the credibility findings? Do you read the BIA opinion the same way I do, which is the BIA saying there was sufficient evidence? But to be clear, we're not endorsing everything the IJ said about credibility, that we're limiting ourselves to the stuff we're talking about in the opinion. And then there's a footnote saying there might have been some other stuff, but we're not endorsing that.
Yeah, the
Okay, well,
BIA
that's
typically.
unusual.
It's not unusual. It's actually
It
quite
seems
common.
unusual, but
under-
which of the, it seemed to me that the BIA was excluding the part where the IJ says they gave more information than was necessary in response to questions? Was
Right,
that
yeah.
one of the things?
That
Yeah.
was one. The IJ made finding that the petitioners, I think collectively, offered a whole bunch of evidence, kind of
Yeah,
a
because it is
hurricane of
weird
evidence.
kind of to fault people for that, right? Like as
I don't
people
know,
go
I've not
into
seen
these
it, but-
hearings, there's a lot at stake. They get asked questions, they offer up everything they can think of that might be responsive.
From the cold record, it's hard to tell. And there's actually not a lot of country conditions evidence placed in the record. The other findings that the board left out were the IJ's findings about Clelia, her sort of irritability. And then there was another one about certain omissions. They didn't follow through on that. So, but that's not unusual. And under INS v. Bad, they don't have to set findings
don't
on
have
anything
to.
they don't feel necessary. So it's pretty common for them. The board actually did address everything else that petitioners offered up. Besides that, which they set aside, the petitioners had concern about whether the IJ addressed their personal circumstances, by which they meant their trauma, their lack of education. The IJ noted that, the board held that, basically rejected it by saying it doesn't really matter. There's two plausible views of the evidence here. The IJ picked one, he doesn't have to pick the other one, that's a matter of DR.
Did the IJ consider the expert declaration about the impact of trauma on memory?
No, he didn't, or at least not specifically. He did say he considered all the evidence, but the impact of trauma on memory was not offered for one of the many times that he asked the petitioners to repeat themselves or clarify. The petitioners never offered anything other than their illiteracy, basically, or their poor memory, based on the fact that they couldn't, follow calendars or count money, as a reason for why they weren't able to recall these dates. So they never said, well, I'm traumatized, so that it was hard to remember. They never also brought up the technical difficulties that petitioners mentioned as well. So the IJ doesn't err by not considering explanations that weren't given.
But they weren't able to read their sworn statements because they weren't able, and so their statements contradicted their sworn statements, which they were unable to read.
They did. That was a major part of their credibility issue. They have these sworn statements, what they've signed, and Clelia actually explicitly disclaimed her statement. She said, no one ever read that to me. Everybody else, they didn't disclaim it, but we presumed that somebody read them to them. They had attorneys. Again, they didn't offer this up as an excuse. They've signed them, so that's a statement right there. And that was part of the problem. The major issue that the petitioners brought up, or concede in their reply brief was the problem with the timeline of the kidnapping. Clelia testifies that Jonathan, who was born in 2004, was kidnapped when he was 7 years old, but her statement is that he's kidnapped when he's 10 in 2015. She doesn't reconcile that. She just says, oh, I never saw that statement. But the lead petitioner testifies that Jonathan was kidnapped when he was 7, but he also testifies, this is not in his statement, it's in his testimony, that it was 2015, and he reaffirmed that. He said, I was confused about the years, I can't read or write, but he never retracted either one of those things. It's an impossibility. Fernando, the brother, says Jonathan was kidnapped at age 7. Jonathan himself, the victim, says, I was kidnapped at age 7. So that's 2011 or 2012, but we still have the father saying it happened in 2015. That's not reconciled. The sister, Christella, in her statement says it's 2015. All of these irreconcilable facts placed into the record by the petitioners aren't reconciled. It doesn't matter that the parents can't read or write. They're not the ones, it's not, their illiteracy doesn't affect who wrote what or who said what. It's all there. The children and the parents both, and we don't know anything actually about the children's literacy.
Can I ask you to address I don't mean to take you off course, but I think you said at the beginning that this is all really one claim, and I didn't understand that, and I want to give you a chance to address the bias claim.
Absolutely. So you mentioned in the beginning, Judge Haytens, that their bias arguments are the same as their credibility arguments, with the added gloss that no one who has these opinions could say these things. And that's true, which is why the credibility finding kind of deals with the whole thing. But I think it's important, as we're addressing this now,
I'm
to
sorry,
look.
what do you mean that the credibility determination, I really don't understand. What is your point? The credibility determination deals with the whole thing? What are you saying?
Sure. Well, let me start from the top here. Let's start with how this claim evolved. So the petitioners.
You know, just because we have such limited time, I absolutely understand the points at which things were or were not exhausted. I guess I just want to take you right to the meat of it, because I really did not understand your brief, once you get to the merits
Okay.
of the bias claim.
Right, I'm addressing the merits here.
Okay,
So-
great. So there's this line of cases that says administrative law judges, like IJs, violate due process if they have prejudged a case, they have a closed mind. And I guess I'm trying to figure out why that is not at least implicated if you have a judge running around saying 99% of these claims are baseless.
It's not at all implicated, and there's no evidence of bias in this case. There's an
What do you mean, there's
allegation.
no evidence of bias, like, in the world, or there's no evidence of bias that's properly before us because it wasn't put in the administrative record?
I would say both. There's an allegation of bias. We have statements from the IJ made before he was ever an employee. We have statements from the IJ which are not properly before the court.
Understood, but still, let me just
After
give you a
you're an employee.
hypothetical, just because I'm worried that we keep getting, like, the clock is ticking, it's making me very anxious. Just take it out of this case. There is a Social Security judge, and he is running around town saying 99% of these guys are making it up. 99%, it's all just made up, they just want the money. And now I'm before him with my Social Security claim, and you're telling me there's no bias problem here.
Bias has to manifest in the case.
No, it doesn't. That's the part of your brief I didn't understand. Then what's the point of a bias claim? If you have to show, and that's why this mistake got made in my case, what's the bias claim doing?
The bias claim isn't doing anything because it.
So
it's
you
a-
just don't believe there's such a thing as a due process violation based on bias? You have to show the specific mistake that was made in your case.
No, you have to connect a bias to the petitioners or their
That is your
claim.
But that's
Understanding.
clearly,
So-
all right, Caperton.
Right, I don't.
Caperton, there was no showing that the Supreme Court Justice of West Virginia, that the U.S. Supreme Court said had to recuse because of a due process problem. There's no showing that he did anything wrong in the particular case he adjudicated. I mean, he obviously ruled against the petitioner because otherwise the petitioner wouldn't have sought Supreme Court review. But other than ruling against the petitioner, there was no allegation that he did anything in that particular case that was bad. It was that he is a biased judge and thus is constitutional. I'm not suggesting there'd be a constitutional problem here, but that he is incapable of hearing the case. The whole point of recusal is this decision maker is not allowed to decide this case. It's not that I'm taking issue with the specifics of what he or she did. This biased decision maker can't do this. And you're telling me that in immigration, there's just no such claim as that?
No, I'm not telling you that. What I'm saying is these cases show that the bias manifests when it can be specified to the petitioners or their claims. Sometimes if a judge is speaking in generalities, he can manifest a bias so severe that it can be imputed to the claim.
Why isn't 99%, I guess I want you to come back to the statement, why isn't 99% of my hypothetical Social Security claims, they're just bullshit, people just want the money? Like, how is someone supposed to feel like they are getting a hearing in front of an impartial tribunal if the judge has already said 99% of these cases are made up? What if it was 100%? Would that be okay?
I don't think that would be okay, but
Oh,
that's
so
not
that's
what
what
we
this,
have
the difference here
here.
is
No,
that?
I would like to explain. I know you're kind of, you want to hear me explain it, I'm going to explain it to you, but
Oh my God.
due process doesn't require that the IJ never engage in any hyperbole or never express any cynicism, especially when he's not a federal employee. This person,
I just want to work backwards. So 100%, you think, this is, for me, this is an important concession, so I just want to make sure I understand it. If the IJ had said 100% of these claims are baseless, then you would agree that the petitioner wouldn't have to show the error in his particular case. That would be sufficient. If the IJ
would-
said 100% of the claims are
it would
baseless,
depend on the circumstances of the
what
statement.
else would you need?
It would depend on the circumstances of the statement.
else
If he's testifying in court about how he feels about a thing, I think it would be so cartoonishly unlikely for a person to say, these claims never amount to anything and actually mean it.
I kind of feel like that's what he said.
I know, I can tell.
So you think he didn't mean it?
No, and there's no reason to impute that he did. This is
Well,
just.
isn't the
I-
natural inference that people mean what they say? Wouldn't you have to come forward with some reason to show he
99%?
didn't believe it?
99% is a common hyperbole. 99% of these claims, this is all junk. Remember, this is
So if a judge in a criminal case says, obviously 99% of black defendants did it, you're like, that's fine. He's probably just hyperboling.
I'm not going to opine on that. I'm
Why
talking
not?
about
It's
because
this
we
case.
no, this case is an IJ who has a political opinion about the immigration system, saying that he
No, that's
wishes
not a
it would be
political
different.
opinion. A political opinion is the asylum, like, so he said this, the current asylum system is broken, there are serious problems, we don't catch some of the people that should get relief don't get relief, some people who do get relief shouldn't get relief, we need to reform it. That's a political opinion. 99% of these claims are baseless, is a statement of fact about the world. And I think just as we would say, a federal trial judge who said 99% of criminal defendants are guilty and all of their arguments are BS, I suspect that criminal defendants would have an extremely plausible due process motion to recuse those judges. If a federal district judge said that, I think they have a real recusal problem, don't you?
Immigration judges, like all judges, are allowed to have opinions.
Of course they are.
They're allowed to have political opinions.
Sure.
They're allowed to have political opinions about the subject matter over which they have
100%.
expertise. We don't impute bias unless it shows.
Until they
somehow.
open their mouth and say something that sure sounds like it's biased.
If we did not know that this immigration judge had this opinion, where is the bias in this case?
So your position really is that you want to come back to, you have to show the error in the proceeding, the bias itself. So you want to kind of take back, even if someone testifies in Congress, my considered view is 99% or maybe 100% of these claims lacks merit. That is fine if you can't show how that bias manifested in a particular case. Because I read the cases you cited for that, they don't say that, and this would be a real sea change in how we understand bias claims when it comes to judicial officers. So I just want to make sure I understand the government's position on this.
The facts of those cases support the position, but I'm not going to come and say an IJ could never say anything. Obviously, you could imagine things. You've all been imagining them as I've been talking to you. Just as the petitioner has imagined that there's a bias here. Ironically, the only way to impute bias is to presume that the IJ has prejudged a case based on his comments. I don't think that's how due process works, but I'm prepared to let due process go because, again, we don't need it. This case can be decided on the merits and it can be decided on exhaustion.
I don't know what you mean when you say I can let due process go, we don't need due process. I mean, you're not bringing the challenge.
Because there's no prejudice. Because on the merits.
Again, I don't think that usually in cases involving a biased judge, at least an Article III judge, you have to show prejudice. It's the kind of structural error where we say that you don't have to show prejudice. You did not have a fair judge,
In fact,
period.
hasn't the Supreme Court literally said, like, the Supreme Court has said over and over again, almost nothing is structural error, but one of like
One thing.
3 things that are structural error are a biased trial judge.
Due process, as far as I know, the cases that I cited, due process violations have to show the bias and the prejudice. There's no prejudice here.
So why was Justice, I've forgotten his last name, why was Justice so-and-so required to recuse in Caperton?
I don't know.
Okay, what is your best case for the proposition that if you can show a biased judge, you still can't win unless you can show that that bias prejudiced you?
Whatever it was I cited, I'll ask your forbearance
God.
here. The device that I brought to use the record here from the government actually stopped working.
Yeah, and
so
also the pages of the brief don't hold together, so we're all at a disadvantage, but I'll
This
try
is
to
going
find it.
great. But that would be the argument. It's either exhaustion, if I can't get you on board with there's no bias from the 4 corners of the decision, because there's not. If I can't get you on board with that, then I can get you with exhaustion, because it's not exhausted. The petitioner never presented this. He presented it just specifically from the findings that the IJ made in the first decision. That's what I meant by credibility and bias are resolved on the same issue in 1716. The other comments are not before you properly. That's statutory in 1254B4A. You cannot consider them. And the other comments that the IJ, that the petitioners brought to the court, the board for reconsideration, were not considered. It was an alternative holding, as you said. You can't bring arguments you could have brought to the board previously on reconsideration. That's a motion to reopen. They didn't file that. So again, I mean, they did end up deciding it on the merits, but you don't need that.
Oh, I'm sorry. I found it. I think you want Lightke? I might not be pronouncing that right.
Leaky, I think it is.
Yeah, so you guys, the government should argue its cases however it wants. That's not what that opinion is talking about. That's the opinion about how It's not impermissible bias if you develop it sort of during the course of proceedings itself. If the judge, during the course of proceedings, learns that the defendant becomes exceedingly ill-disposed towards the defendant who has been shown to be thoroughly reprehensible, that's fine. The problem is if he comes to the proceedings having already prejudged that, and that's what's being alleged here. So I thought this case was really not on point, but I'll leave that.
There's also a temporal issue here. You know, again, these comments came before he ever worked for the agency. There's no comments that I'm aware of while he was working for the agency. I don't recall offhand how long before the judge held this hearing, but we know it was quite a while after the judge held this hearing that he made his other comments. Not that they can be considered. But again, I'm going to go back to the merits of the credibility case. I went through the kidnapping. I just want to say the petitioners they were trying to set their claim up for asylum, right? Immigration judges can do these, can view credibility issues as they see fit. That is the law. For an asylum claim, the petitioners have to show persecution, but they could not keep straight what happened to them and what they did about it. They have to show that the government is unable and unwilling to help them, but they couldn't correctly identify either or couldn't confidently relate whether they ever went to the police. Their testimony was vague. That's in the record. It's not bias. They couldn't answer basic questions. That is in the record. It is not bias. Is that a record that compels the conclusion that the IJ was wrong? No. The answer is no. Unless there are further questions, I'm going to stop there. Thank you.
Your Honor, just briefly, if you turn to page 6, which is the board's initial decision, they said, for example, there that when they were deciding that the immigration judge is finding that the respondents did not submit sufficient independent evidence, they faulted, again, Jose for not having included a copy of his passport, which, again, we pointed out is factual error. And we believe if the court were to just rely on the credibility finding itself without getting to the bias issue, we believe there's, again, sufficient cherry picking or overlooking of the evidence for remand. As for going to some of the other issues, I mean, I completely agree with the government that this individual has a right to free speech. However, he doesn't have a right to be an immigration judge. He doesn't have a right to hear a specific class of asylum applicants. And so I think that's where the distinction goes. And I take Judge Harris's point that if certain types of judges, criminal or Social Security judges, were to make comments about a specific class of individuals that are going to come and litigate cases in front of them, that's the difference here. And I don't know that I would necessarily get into a 99 or 100% threshold argument, but I think just the tenor themselves in the totality rise to the level that somebody has an appearance of bias. With regards to the sort of mathematical errors that are taking place, if the court looks at the testimony of all the individuals, they all agree that the year the act took place of the kidnapping was in 2015. Where it gets confusing is they also all agreed that he was 7 years old when it took place. At certain times, both DHS and the judge try to walk them through the math of it, and they just sort of appear oblivious. And so again, I think given that they all consider that it took place in 2015 and we have the corroborating passport stamp, I think the court should say that there's at least enough, and that explains the confusion of why they're just terrible at math. And regarding the $40 versus the $7,000, if an individual were to come up to you in the street and say hey, can I get $40 from you? And even though you had the $40 or were planning on giving them the $40 but didn't, that's a lot different than that same individual then kidnapping your son and then you having to come up with $7,000. Obviously, the level of emergency is what dictated his reaction there. And then the government also faults them for they never explained that they were suffering from trauma while they were testifying. And that's not something that you would expect an unsophisticated witness to necessarily explain on the stand, that I'm damaged from trauma and that's why I'm having difficulty to recall. I mean, that's the job of experts, that's the job of litigants to help try to explain, and that's what we've tried to do through both the board litigation and before the court today. And the last thing I would say is that bias can always manifest itself in a credibility determination, because again, if you want to nitpick, if you want to find somebody unbelievable, if you want to find something in their demeanor, just take reasonable suspicion, for example. There's cases where a cop can pull over an individual because they weren't looking at them, or they were looking at them too much, or they were looking at them, not the right amount. And so that's the same kind of thing. That's the deference that we give to fact finders in this case. And so we just take the position that if the court has to, that a credibility determination itself, there is the manifested prejudice that the government is requesting. And we would ask the court grant the petition for review. Thank you.
All right, we'll come down and greet counsel, and then I'll ask that the court be adjourned for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.